Has Trump put up entry into the US for sale? What is the gold card proposal? Will it replace the existing EB-5 visa program? US President Donald Trump recently unveiled plans to sell $5 million gold card resident permits to non-Americans worldwide, a long-term visa policy that might eventually offer a pathway to citizenship for the global economic elite. This new visa will replace the existing EB-5 immigrant investor visa for foreigners who can create job in the US. The latter the latter, an option that Mr. Trump's Commerce Secretary Howard Lutnick has attacked as full of nonsense and make believe and fraud. The EB-5 was introduced in the 1990s with an explicit aim of attracting foreign investors to the US via the residency route, only requiring that they create and support jobs on US soil via direct investment of capital. The investment levels are at 8 lakh dollars in a targeted employment area, one that faces certain level of economic distress, and the 10 lakh 50,000 outside such areas. Critics of EB-5 program, primarily in the Trump administration, highlight the scope of abuse and fraud within the scheme, while aggregate figures on the scale and frequency of EB-5 fraud and abuse are not available. There is significant number of documented cases involving misuse of investor funds. For example, developers diverting millions of dollars intended for projects towards personal use. In terms of governance, the US Congress is responsible for determining citizenship qualifications. In this regard, Mr. Trump has reportedly said the congressional approval may be unnecessary for the gold card visa, an approach that might cause consternation on the Capitol Hill. Mr. Trump, while announcing the scheme, expressed hope that if we sell a million, that's $5 trillion, and I think we will sell a lot because I think there's really a thirst. He also noted that future recipients of the gold visa will be wealthy and successful, and they'll be spending a lot of money and paying a lot of taxes and employing a lot of people. However, close to 75% of the billionaires polled by the survey that asked if they would consider this visa indicated that they would not opt for it, primarily because all at that level of wealth they anywhere could set up businesses in the US at a lower cost, have options to reside on the US soil, and could avoid the US tax cut on a global income. Yet there appears to be lack of clarity on on the tax front. While Mr. Trump has said gold card holders will not be subject to taxes on their overseas income, this would imply that gold card residents will be able to purchase a tax benefit not available to US citizens, effectively creating dual classes of taxpayers among American wealthy. That might contravene certain regulations or potentially cause political blowback for the White House if passed into law. If were if we were to compare the experience of other advanced economies, both the UK and Australia have experimented with similar golden visa initiatives, yet in both countries it was scrapped after interest peaked a few hundred applications per year. According to London School of Economics professor Christian Surak, Greece, the Netherlands, Spain, and Portugal had similar experiences. Ms. Surak's 23 book, The Golden Passport, examines global market for citizenship and wealthy elites who buy their way through it. The UK trial into the gold card type programs raised another concern. Former Home Secretary Suella Braverman said once to the UK Parliament that closer examination of visa grantees indicate that some were potentially at high risk of having obtained wealth through corruption or other illicit financial activity, or being engaged in serious organized crime. When he was recently asked by media whether Russian oligarchs would be eligible for the card, Mr. Trump said, "Yeah, possibly. I know some Russian oligarchs that are very nice people." How does this tie in with Trump's immigration paradigm? Trump administration is currently in the process of carrying out mass deportations of undocumented migrants in the US. So even so, his White House has strongly supported legal migration. Adding to this, the MAGA focus on gaining transactional advantage through deal making with other nations, and the gold visa scheme makes perfect sense as a means to monetize entry into the US while spurring job creation. The test of the success of the program will depend upon the numbers of those who take up the gold visa offer. Why is India staring at an obesity challenge? Is there an urban rural divide? How are prices affecting the right food intake? Why does the rise in obesity have bearing on non communicable diseases like diabetes? Why is childhood obesity an area of concern? And what is likely to happen in adolescent and adulthood? Earlier this week, Prime Minister Narendra Modi, in his Mann Ki Baat radio program, highlighted the alarming increase in obesity in the country, particularly among children, and noted that obesity affected 1 in 8 Indians. Mr. Modi urged people to reduce oil consumption by 10% each month and stressed that to build a healthy nation, obesity needed to be addressed. Overweight and obesity are defined by the World Health Organization as abnormal or excessive fat accumulation that presents a risk to health. Abnormal or excessive fat accumulation that presents a risk to health. Abnormal or excessive fat accumulation that presents a risk to health. Data from NFHS reveals that obesity has been increasing across India over the years. The percentage of women who are overweight grew obese from 20.6 in during NFHS to 24.24% NFHS 5. Percentage of overweight or obese men increased from 18% to 20% during the period. Urban numbers were significantly higher than rural numbers. 2023 research paper in Lancet analyzed the NFHS5 and found the prevalence of abdominal obesity at assessed through waist circumference. Abdominal obesity assessed through waist circumference. Abdominal obesity in the country was 40% in women and 12% in men. Childhood obesity is also an area of concern. The percentage of children under 5 who were overweight rose from 2.1% to 3.4% from 2015-16 to 2019-21 as per the NFHS data. With older children, the figures are higher. The World Obesity Atlas 2022 estimates that India will have a child obesity prevalence of 10.81% among 5 to 9-year-olds and 6.23% among 10 to 19-year-olds by 2030. According to the WHO, obesity in adulthood is a major risk factor for the world's leading causes of poor health and early death. These include cardiovascular disease, several common cancers, diabetes, and arthritis. India leads the world in the number of people with diabetes at an estimated 101 million. The burden of cancer is on the rise from 14.6 lakh cancer cases in 2022. The number is projected to go up to 15.7 lakh in 2025. As per the ICMR National Cancer Registry Program, moreover, the cardiovascular disease remains one of the leading causes of death and disability, reportedly affecting Indians at least 10 years earlier than in other countries. In fact, non communicable diseases now account for about 60% of all deaths in India. Being overweight in children and adolescents, the WHO says affects children's and adolescents' immediate health and is associated with greater risk and earlier onset of various NCDs. It can have adverse psychological consequences affecting school performance and quality of life, compounded by stigma, discrimination, and bullying. Children with obesity are likely to be adults with obesity. Rising levels of obesity in urban India are due to combination of multiple of factors: unhealthy diets loaded with ultra processed foods, lowered levels of physical activity, and even air pollution, which provokes inflammation and predisposes the body to cardio metabolic diseases and visceral adiposity to the body. Cost is another factor. Low income households, especially those that depend on public distribution system, eat more carbohydrates through rice and wheat, says public health professional Vandana Prasad. You can instruct people to eat better, but if it is not possible if these foods are unaffordable. Indian diets, especially among poor families, are deficient in iron and proteins. Foods like families, vegetables, pulses, dairy, and animal based foods are expensive. While at present obesity is primarily an urban middle class phenomena in India, it is already rising among the rural poor, which may soon overtake the other segments. A study in the Lancet Global Health last year said almost half of all the Indians are not sufficiently physically active, even as indoor sedentariness is increasing due to seated nature of office work and use of digital devices. Outdoor conditions are not conducive to safe and pleasurable physical activity. Absence of safe cycling lanes and pedestrian paths are compounded by dimly lit lanes. Green spaces available for recreational physical activity are shrinking, while traffic density and rising street crime deters walkers in many urban zones. While the usual metric to measure obesity is the body mass index, there has been a growing debate about its limitations. BMI does not indicate how much of the weight is fat and where the fat is distributed in the body. Fat in the abdomen, particularly, is something that Indians are generally predisposed to accumulating, contribute to metabolic syndrome, a group of risk factors that increases the chances of developing type 2 diabetes, stroke, and heart disease. This January, experts in India issued updated guidelines for obesity treatment and diagnosis that place special emphasis on abdominal fat distribution. This classification introduces two stages in obesity. First stage, where there is increased adiposity without discernible effects on organ functions or daily activities, and the second, where both physical and organ functions are impacted. It recommends that use of waist circumference or waist to height ratio and body fat measurements alongside BMI to diagnose obesity. In this January, experts in India issued updated guidelines for obesity treatment and diagnosis. Classification introduced two stages. First stage, where there is increased adiposity without discernible effects on organ functions, and second, where both physical and organ functions are impacted. It recommended the use of waist circumference or waist to height ratio and body fat measurements alongside BMI to diagnose obesity. What were the objections to the new Advocates Bill? Why has the Advocates Amendment Bill 2025 been retracted now? And why is the Bar Council of India peeved with some of the proposed changes? Why are some of the amendments being seen as an effort to undermine judicial independence? On February 22, the Centre withdrew the contentious Advocates Amendment Bill 2025, stating that a revised version incorporating public feedback will be introduced. The bill sought to amend the Advocates Act 1961. However, its introduction faced strong opposition from sections of the bar. The government's decision to retract the bill followed a letter from the Bar Council of India to Union Minister Arjun Ram Meghwal, pointing out that the proposed amendments threatened the autonomy and independence of the bar. The Law Ministry underscored the need to amend the 1961 Act to address contemporary challenges and align the legal profession with global best practices. It pointed out that seismic shifts in the legal landscape necessitates reforms to better equip lawyers for a rapidly evolving world. The draft bill comes over a year after introduction of the Advocates Bill 2023, which was passed to eliminate touts and curb superfluous enactments in existing statutes. A key point of contention in the bill is its proposed ban on strikes and boycotts by lawyers, citing their disruptive impact on judicial proceedings. It includes the Section 35A explicitly prohibiting advocates and bar associations from abstaining from court work. Violations would constitute misconduct, subjecting offenders to disciplinary action under 1961 Act and the Bar Council of India rules. However, the bill clarifies that restriction does not apply to strikes that do not impede the administration of justice and about and are intended to address legitimate concerns about professional conduct, such as working conditions or administrative issues. Senior advocate Chandar Lal underscored that strikes are legitimate means for lawyers to voice grievances. The bill's withdrawal was a direct consequence of the protest led by various bar associations. However, the court boycotts and strikes inevitably disrupt judicial proceedings, ultimately harming litigants. That said, I believe the bar exercises restraints and resorts to strikes only in cases of extreme exigency. Echoing similar sentiments, the advocate Nipun Saxena pointed out that strikes have historically served a powerful tool for the legal fraternity to oppose state excesses. Barrister Dr. Saifuddin Kichlo was among the earliest vocal opponents of the Rowlatt Act 1919, which granted the British government sweeping powers to arrest and detain individuals without trial in colonial India. He organized widespread boycott of British courts by Indian lawyers. Lawyers have long stood the first line of defense in safeguarding the rule of law and preserving constitutional values. The proposed law allows the center to nominate up to three members to the BCI, along with along its existing members, Attorney General, Solicitor General, and representatives from state bar councils. The BCI has strongly opposed this provision, calling it draconian and arbitrarily inserted. The bill also introduces Section 49B, empowering the Centre to issue binding directions to the BCI, set Bar Council eligibility criteria, and regulate the BCI's oversight to state bar councils. Since the government is its latest largest litigant, it should have it should have no role in autonomous body like the BCI. Such influence would undermine judicial independence as advocates serve as officers of the court. The amendment significantly expand the BCI's authority, potentially rendering state bar councils redundant. Traditionally, misconduct complaints against advocates are handled by the disciplinary committees of state bar councils. However, Section 45B now allows the BCI to hear complaints nationwide and suspend the advocates at its discretion. Additionally, Section 48B of the BCI to dissolve the State Bar Council and replace it with a committee if it deems the council it is ineffective. Mr. Saxena argues that these changes undermine the federal structure of the 1961 Act. The BCI and the State Bar Councils were created under distinct provisions. Stripping state councils at their core of their core functions reduces them to mere administrative bodies and with no real authority. The bill expands the definition of legal practitioner under Section 2(i) to include lawyers associated with foreign law firms, corporate entities, and practicing advocates. It grants statutory recognition to corporate lawyers working in law firms and as in-house counsel, a long-standing demand that has gained momentum. Additionally, the bill empowers the center to formulate rules governing the entry of foreign law firms and lawyers into India. The Bar Council of India rules for registration and regulation of foreign lawyers and foreign law firms allows foreign lawyers and firms to practice law in India on a reciprocal basis. However, these rules were later challenged before the Delhi High Court, with petitioners arguing that the BCI lacked the statutory mandate to permit such practice. The proposed change would have had little impact on corporate lawyers and law firms, as more are already licensed advocate. However, its implications are far more significant for in-house counsel. A crucial question is whether this move intends to gradually blur the distinction between advocates and legal practitioners. For instance, would in-house counsel be granted rights of audience between courts, before courts, arbitral tribunals, and judicial fora? Moreover, it could have definitely settled the long-standing debate on whether legal privilege extends to advice provided by in-house counsel or to their employees. He further pointed out that while the structured entry of foreign law firms in India is a welcome development, the proposed law framework remains ambiguous. Jurisdictions like Singapore serve as valuable precedents, having successfully balanced the interest of international law firms and the domestic legal fraternity. However, for regulations introduced by the Center to be effective, they must be formulated by consultation with all stakeholders. The bill's withdrawal is a welcome step, and one hopes that that inclusive dialogue will lead to meaningful reforms. Any changes must safeguard judicial independence and autonomy of regulatory bodies. Mr. Saxena further underscored the need to consult high courts before implementing any reforms, noting that Section 34 of 1961 Act empowers them to regulate the practice of advocates before them and subordinate courts. So that's all. See you in the next one.